That's what yeah. And just put it here. Okay. Okay. We're ready to start? Come in. Good morning, everyone. I think it's 9 o'clock. Let's go ahead and get started. I'm Rhoda Whitaker-Kriz, and on behalf of the Winchester Frederick TRIAD and the SALT Council, I welcome each of you here today. And we are happy to greet our Westminster Canterbury guests who are watching this on their television this morning. And we also thank Westminster Canterbury for the use of this room and for the delicious breakfast that they have provided. This morning's workshop is the second in a series of 3 that's being sponsored, presented by the SALT Council as a result of the interest expressed at the Spring Festival. The first session addressed advanced medical directives. This one will talk about powers of attorney, and the next one coming up, the third and final one, will be on wills, and will be presented right here on September the 30th, Tuesday, September 30th, from 9 to 11. And I have a request for each of you to do. If you'll take a sheet from your notepad and write on it ideas that you would like to see presented so that we will know how to plan for our next Spring Festival and for any workshops that we can conduct through the years. You know, in this day and age, many organizations and companies are known by their acronyms. You know, the SPCA, CCAP, KFC, UPS. Well, if you look at TRIAD, TRIAD, you might be trying to figure out what that stands for, because it certainly looks like it would be an acronym, like I was wondering when I first saw that word. But TRIAD really is a word, and it means a group of 3 connected people or things. TRIAD was started about 1988 as a partnership between AARP, which would represent all of us seniors, and the International Chiefs of Police and the National Sheriff's Association. That's at the national level. It was adopted in Virginia in the middle 90s and involved the Attorney General's office, the local law enforcement, and seniors, and all the organizations that provide services for seniors. Our Winchester Frederick TRIAD is composed of the local law enforcement, which is Winchester Chiefs of Police, City Sheriff, Frederick County Sheriff's Department, and seniors, and the organizations that provide services for the seniors. And the mission for the TRIAD, I'll just read to you our mission statement. It's committed to improving the quality of life for our seniors by enhancing their health, safety, and security through communications, education, and outreach. We work together to reduce the criminal victimization of the elderly and to enhance delivery of law enforcement services to older persons. Now, within the TRIAD, we have the SALT Council. Now, the SALT Council is an acronym, and that stands for the Seniors and Law Enforcement Together. And we meet regularly, and we have the SALT Council made up of the Winchester City Police Sheriff, Frederick County Sheriff, and all of the organizations and companies that provide services for the elderly. And my husband, George Kriz, and I are honored to be the co-chairs and to serve as the lay members representing the seniors of Winchester and Frederick County. The SALT Council is responsible for today's workshop, and we sincerely hope that you're going to benefit from the information provided here today. And I want you to remember this is a very informal session, so please feel free to, anytime you want to get up and help yourselves to something at the breakfast, please do so. And if you have questions, please feel free to answer them. But because it is being televised, we do need to use the microphones and wait until a microphone is brought to you. So at this time, I want to introduce Stephanie Landis, and she's going to tell you a little bit of the housekeeping.
Good morning, everyone. We are so thrilled to have you here. Thank you so much for coming. As Rhoda mentioned, my name is Stephanie Landis, and I'm the Director of Development and Community Relations here at Westminster Canterbury. And we are so happy to host this TRIAD event. A couple housekeeping items, if you will, before we get started. We have restrooms that are right outside these double doors. If you go out and turn to your left, the men's and women's room are right there for your convenience. So feel free to exit as you deem. Secondly, if you will, please remember to turn off or put your phones on silent. That will help cut down on some of the distractions. Yes, you don't want to be that person. And again, because this is being televised and actually recorded too to share with those who are not able to attend today, if you have a question, please raise your hand and I'll come running with the microphone to make sure it's heard. So again, thank you so much for coming. We're thrilled to have you, and I hope you find today's session to be very informative. I'm going to now introduce you to Josh Hummer, who's going to be serving as our MC of the event, if you will, for our speakers. And we'll take it from there.
Great. Good morning, everyone. My name is Josh Hummer. I'm also a member of the SALT Council, and another big thank you to Westminster Canterbury for hosting this event. This is a great venue, and we're really excited to have you here. Last time we talked about advanced medical directives, and those of you who are here, remember you had to put up with me for a very long time talking about what is admittedly a very boring subject, but hopefully you got some information, and hopefully in particular some of the other speakers were able to give you some real-life examples about advanced medical directives. If you missed that one and would like that information, we will be putting up a link on our website to, or on the Winchester City Police's website to that video, so you can go back and watch it again and again and again. But today we're excited to focus on powers of attorney, and I'm even more excited because my job is about to end. I'm just going to introduce the speakers we have lined up today, and then I'm going to turn it over to them and let them educate you about powers of attorney. I'm very excited about each of these speakers because we not only have a legal expert on powers of attorney who's going to talk to you and give you some background, but then we have several folks who deal with them on a day-to-day basis, both from the banking perspective and from the care industry. But we're going to start with the attorney. Suzanne Herskovitz is her name. She's sitting right there in the back. And so I've known Suzanne for, 4 or 5 years. Her practice focuses on estate planning and elder care. And so I'm going to let her tell you a little bit more about herself. But Suzanne, if you'll please come and share with us about powers of attorney. And Suzanne, I forgot to tell Suzanne a number of things about today. One, that she was being on camera. So you'll forgive her for if she's a little mad at me about that. But also, you do have to hold this mic. So surprise number 2 for the day.
And so he told you that advanced medical directives was boring. Powers of attorney is probably even more boring, but we'll do our best. Okay, so my name is Suzanne Herskowitz. I am an attorney here in Winchester, and I have been practicing law, I guess, almost 28 years now. So I started when I was 3. And I have known Josh now for a number of years, and I thank him for allowing me to give you this information. Powers of attorney and medical directives are passions of mine because I think they're things that people really need to focus on and very often don't. They immediately want a will, but my view is you have to have the others as well. So, first, we need to talk about, well, what the heck is a power of attorney, and why you need it and how you go about getting it. So that's your definition. It's a document. It's a legal document. And it allows you to give the authority to somebody else, generally called your agent. Many of you may have heard the term attorney in fact used, to handle your financial affairs, your money, your real estate, and any personal property. This has nothing to do with your medical care. This has to do with your assets. So it's a legal document that allows somebody else, that allows somebody else to handle your money, your real estate, and your property. So there are many kinds of powers of attorney. You have limited versus general. A limited one would be like if you were selling your house and you gave somebody the specific power of attorney to go to the real estate closing for you, and that power of attorney has one purpose, and that purpose is to close the house deal for you and to sign on your behalf. General means everything, all your money, all your property. Durable versus springing. Durable means that it survives any incapacity that you have. That's the one a lot of people want, because they want their family and their agent to be able to handle their affairs if they no longer have the ability to do it for themselves. Springing, on the other hand, means just what it says. It springs into effect upon your incapacity, meaning the person has no authority to handle your financial affairs until some trigger, generally your incapacity, happens. Agent and principal. The agent is the person that you authorize to handle your affairs for you, sometimes also called an attorney in fact, although agent is now the correct term under the Uniform Power of Attorney Act. Principal would be you. You're the person giving the authority to the other person, to the agent. An attorney in fact is the other term that is often used. So, why do you need one of these documents? They're long, they're full of legalese. You may not be able to pay your bills or manage your assets. If you have any incapacity to handle your financial affairs, you'd like somebody else to be able to do that for you. And this is one very big key benefit, is avoiding the need for a guardian and conservator. The conservator being the person that would handle your financial affairs, and the guardian is the person that takes care of you. Because that is a very long and often expensive proposition, and it's also fairly traumatic for your family to have to go through it. So having a power of attorney assists you in avoiding that process. So there's some other problems. Maybe you're just not capable of paying your bills anymore. You're getting late notices, and your Comcast bill is, your Comcast, one day you go to turn your TV on and it's not working. They can be used for tax avoidance. In other words, nobody is going to be able to help you with Internal Revenue or anybody else if they don't have the authority to do it. Whoops. We'll go back to that. That's me at the bottom there. Okay, so places to get a power of attorney is someone like me or Josh or, an attorney. Now, personally, and I know Josh feels the same way, I recommend that you go to somebody who actually understands these documents and is not just, somebody who really wants to do your divorce. Not that they're not good attorneys, but I don't do divorces. I don't think Josh does either, but this is something that people like us do. So go to somebody, whomever it is, that handles this. And that's the best place to go. Please don't go to one of the online people. I know that you can get it really quickly and generally very cheaply, but they're not always appropriate, and they don't always do exactly what you want. And if you leave certain paragraphs out, you're negating the whole purpose of having them. So we have 6 tips here. Read it carefully. Now, this sounds kind of like you should already know that, but they are difficult documents, and feel free to ask questions about what things mean. Ask one of us, an attorney, if you have any questions about your power of attorney, even one you already have. I signed this thing 4 years ago. I have no idea what this means. Get some advice about what it means and what it means for the person you've named as your agent. Very, very important. Be careful who you make your agent. I like to tell clients that when they ask me, well, what if they tell me they want to name their son or their granddaughter or whomever, what if they take all my money? If you have to ask, you may have chosen the wrong person. And that may sound like I'm being glib, but I'm really not, because I actually had a situation where I was called as a witness in a criminal case right here in Frederick County, where the grandson took the grandfather's money and bought himself a $45,000 truck and then was prosecuted. So they are very powerful documents. And they can, in fact, if the wrong person is named as your agent, they can take all your money. So you have to choose somebody carefully that you trust and that you know is just going to have that power. She's going to come for you. Just have that power just in case, unless you have a springing power, which only takes effect when you become incapacitated. We have a question.
I didn't know I had to be on
Yeah.
camera. Yeah, the camera's moving. My question is, like you say up there, you pick a person, but what if you pick an institution to be, some institution that handles the trust? Okay, now this is the confusing part. Okay, now you have somebody, even though they're local, how do they find out that you're demised or that you have dementia or something? Because I've asked the company that I've chosen to do our end-of-life care and stuff like that, and they find out from Laura, the police.
Mm-hmm.
And I go, well, what if we don't come up for 3 to 6 weeks? What happens? And they go, well, then your property just stays there. And how does the law enforcement and the trustee get, is there a mechanism there to help the person? Because in my case, I'm a retiree. We chose Winchester to live in. I lived all over the world. You name a country, I've been there, and you don't want to go there. But my wife and I decided to pick Winchester as one of the better communities, and we don't really have anybody local. Our nearest relative is like 1,400 miles away. We don't talk to them daily. We might talk to them weekly. But how does that mechanism start here with the local institution that we chose here to be our trustee?
Right.
Am I making myself
No,
clear?
no, I understand what you're saying. So some institutions will not handle a power of attorney. They will not be your agent. They will handle your trust. They will be your executor, administrator when you are deceased. Powers of attorney take effect only while you're living. Once you've died, they're done. So this one does do it all. Okay, and so, but I'm pointing out that some won't. Right, and that is a problem, and it would seem to me that what would be most necessary is to have some kind of action plan with them where they have to check in with you. If you're, well, and then, right, and then maybe it's not the correct, you have to ask if that's the correct avenue for this document then. Because for your trust, for your estate, for a will, they're going to learn about it. They're going to figure it out. Oh, yeah. Sorry about that. You need the microphone again.
I'm sorry. Usually my voice carries and people say I don't need a microphone, but I'm sorry. for them, as an agent, like you say, they handle the whole thing, as far as I can tell. Every question they've answered, but the initiation is the hard part. You know, if something happens to me and the wife in a car accident here, nobody in my family will find out for a week to 3 weeks. They won't find out for a week to 3 weeks. You know, it.
Right. So it means you have to have.
And I have multiple. I have a compound trust because property and assets in multiple states.
Right.
You
so
know, it becomes an issue.
Right. But again, if you're deceased, this has no effect. So the real issue is if you have an accident or something where you're no longer capable, or at least for a short time, not capable of handling your affairs, what mechanism or action plan have you put into place to make sure that they learn about this before your health insurance or, you know, is canceled, or before your bills are going? You need the
Everything, all the bills and everything are automatically paid for us. We have no issues with insurance.
Yeah.
That I'm
well,
aware of.
Okay, so I can't.
I've tried to take care of everything,
right,
except for this little problem.
And so I can't address individually, but what I can say is that you need an action plan with your agent so that they can keep up with you. Because again, you know, the police can't necessarily do that.
No, I understand that.
But there should be a list of phone numbers in emergencies
We
to
do
contact.
carry that in the car, in each of the cars.
And in your house
And in the
wherever.
house.
So those are the types of things you need to do.
But how do you get into my house? I have a gated house. I have 2 different alarm systems. Yeah.
Yeah, this is
put it on
part
my
of.
cell
This
phone.
is all part of that action plan.
Well, yeah, this is part of the thing, but how? You know, I don't know how to fix the initiation. Everything is done, but one thing. And if people say it's personal, it's something you should think about. How you want to live your life.
Okay, so here we go. Talk to your family and agent about your wishes. This is really important. You can't name somebody in your document and forget to tell them that they're the agent, or tell them about what your desires are. I mean, I know a lot of people don't want to have this talk. Sometimes it's the parents, sometimes it's the kids. You know, this is not necessarily a pleasant topic to talk about. My own mother asked me once about, I know you don't want to talk about this, and I had to say, Mom, I do this for a living. You know, I mean, let's talk about it. She goes, yeah, but it's us. I'm like, no, let's talk about it. So this is very, very important. I get people all the time, I'm sure Josh does too, they name people, they put it in their safe deposit box, and then everybody's like running around like a chicken without a head when Mom's in the hospital, or in, you know, put in rehab for a while, and they can't get anything accomplished. So we get to the next point. Tell them where you put the POA. Any of your documents, where are they? You know, they don't want to have to go around to every bank in town asking if there's a safe deposit box. They don't want to have to go looking through every drawer and nook and cranny you have in your house to look for it. They need to know where it is. Now, my personal advice is that POAs and medical directives do not belong in a safe deposit box, because unless you're the friends with the bank president, nobody's going to get it to you at 2 o'clock in the morning on a weekend. It's just not going to happen. So you need to keep it in a safe, preferably fireproof place that your family knows where it's located. They don't have to have it, although sometimes some people give it to their kids directly and they say, here, you hang on to this. And that's an alternative for you as well. But at least tell them where it is. Hang on, she's got it. Yo, you can take my mic.
You can have multiple copies though made of it, and have something stated within the document that a copy is just as good as the original. And that's one thing, you could have several copies made. and have them put in various places, right?
Well, some of that's going to be answered by Wendy and whatnot as to what the third party, a bank or a financial advisor or real estate company, will accept. And they may or may not accept a copy. They may want an original. Now, that doesn't mean that you can't give them the original and have them make a copy and put it on file, which at that point, that copy will suffice. I like to tell people to actually go to their financial institutions with their powers of attorney and say, I just did this. Do you need to make a copy of it, make note of it somewhere in your record? So they know it's there, so that when Junior shows up, 2 years later and says, hey, I need to make a withdrawal or whatever for Mom, they don't say, who are you? Yeah, there you go.
Can it not be put just directly in the power of attorney in the original, saying that a copy is just as good as the original?
That is often in the document.
That's what I meant.
But that doesn't mean the third party bank or whatever is going to accept the copy. They will often want an original signature, regardless. So you do your best. You try and take all, advantage of that, but that doesn't mean they'll accept it.
I just went through this with my mom, and she had original copies signed of her things, 1 of 6, 2 of 6, and they all had original signatures.
You can do that. But he was asking specifically about a copy, not an original signature. Any other questions?
Are these good uniformly throughout the United States or not?
Generally, they are uniformly accepted. And as more and more states adopt the Uniform Powers of Attorney Act, you'll see more uniformity in the documents themselves. Although each state likes to tweak it a little bit for their own needs, they are accepted. Now, that doesn't mean that if there's a difference in yours, the state that you're in is going to consider it based on its own laws. So if you have a North Carolina document in Virginia, it's going to be interpreted according to Virginia law, not according to North Carolina law in most instances. However, they do work.
Suzanne, do you recommend that if somebody has a substantial amount of assets in another state, that they actually get a power of attorney for that particular state, or do you just say just stick with the one from Virginia?
I often tell them to get a new one, just to be sure that there's no glitch in any acceptance of the document. As far as documents go, if you have a substantial amount of assets, it's better to have them the documents reviewed and updated. Even though they don't really go stale either. If you have a 20-year-old document, they were so differently done back then. They were generally 1- and 2-page documents, and I know mine is like 7 or 8 at this point. So it's we kind of put everything but the kitchen sink into them anymore, and that's to make sure that everything is very carefully enumerated in the document. I think we had another question, did we not? Oh. I know nothing. So, are there any other questions? Well, if not, thank you very much.
Thank you, Suzanne. That was great.
We have a question.
We do have a question. Yeah, yes, ma'am.
I purchased Susie Orman's packet.
Oh, goodness.
I haven't looked at it yet. I passed it on to my son. He's interested. But she declares it's good.
Yes.
With her power of attorney.
And I've seen those documents. I actually had someone come to me with one and ask me to review it. And as I recall, unless it's changed, it says, this follows the law of California. Well, I don't know about you, but we're not in California.
Okay.
And
then I wasted my money, except the PBS station gained some money.
well, yeah. Well, I don't know that you wasted your money. It's just it's not tailored for you here in Virginia. Because she has an attorney in California that actually drafts these documents. She's not a lawyer. She can't draft
Right.
these documents for you. So,
Do I pitch it?
I can't tell you to pitch it or not. I would say take a good look at it, have it reviewed perhaps, see what you can rescue out of it. I did not have a good experience with them. They had a lot of things in them that were extraneous to Virginia, documents that talked about community property and whatnot, because we're not in California where all these things terminology and issues would be of need.
But it might be a start for me to look at.
It would definitely give you an education into what you need. No, and I don't mean that in a bad way. It would give you an education into what you should be talking to your kids about and what issues you would like to address. Absolutely.
Okay, thank you.
Sure.
I'm sorry, I have two questions. One has to do with the PowerPoint. You said there were 6 tips, but I think there were only 5 bullets, and I was wondering what was the 6th.
That's his fault.
Okay. All right. You did that last time, so yeah, we understand. Yeah.
And it's my fault too, because when I reviewed it, I didn't catch it.
Okay. All right. My second question has to deal with the contents of a power of attorney. You said the old ones used to be 1-2 pages, and I think that's what mine is. Yours is now around 6-7 pages. So my question is, what are the ingredients? What do you have to have in there? What are the components? Is anybody going to cover that?
Well, and I'm happy to. Years ago, we used to say, we used to give you the statute number and say that this power of attorney covers everything pursuant and included in statute number. And we would give you the statute number. And that was okay. But over time, that was not as good. And the law has changed to some degree to say, for example, that if you wanted your power of attorney to handle real estate, it usually has to specifically enumerate that it will allow the agent to deal with your real estate. And power of sale, especially, power of sale being very important. Another one that has occurred, especially since the Uniform Powers of Attorney Act, is the power to make gifts on your behalf. So, for example, if you regularly gave to PBS or NPR or the American Cancer Society, or if you regularly made gifts to your family, maybe you made a regular gift to your grandchildren, maybe your estate requires you to make regular gifting, or for that matter, people that are planning for Medicaid often will make gifts in advance to reduce their estate in anticipation of Medicaid, or maybe they think they have a tax issue that they need to do gifting. And the power of attorney needs to specifically allow the agent to make gifts. And that is not very often in a lot of these documents. They're very often not in those documents that are pre-printed. The ones that I see people come to me with from online often leave those out. And a lot of people get nervous about seeing that, so they ask why that needs to be there. I don't make gifts. I don't do anything because they don't understand, that even a gift of $5,000 to your grandchild is a gift. And if you make one every year and all of a sudden you no longer can make your own decisions and your agent wants to continue to make that gift, they can't.
And Suzanne, can I add one
Sure.
thing to that? One other thing that's happened, one of the change is that, and I guess this goes back to what Suzanne was saying earlier, the whole point of these documents is to convince, whether it's a bank or whether it's some nursing home or whether it's some sort of care facility, to allow someone else to act on your behalf. And it used to be that just a one page that says, I give Bobby Sue power to do whatever on my behalf. They take it and say, fine. Now, in a lot of cases, they don't, either because it's in the statute that you specifically have to list these powers for them to be available, or they're just more they're more wary. We're a very litigious society. So we, as attorneys, what we like to do is we like to have specifics, so that when your agent goes in there and says to the financial institution, I want to do this, they're pointing to a specific paragraph in your power of attorney that says she can do this. And so there's no way for them to get around that. There's no way for them to claim that it's an interpretation issue or this wasn't what you meant in your broad grant.
Right. We have one more question, and I'm supposed to stand here.
Stay still, Suzanne. We got it.
Since we're looking at all these various possibilities, if you have a guardianship for another person,
Yeah, hold it closer.
Is this working? Oh,
Yes.
Okay, got it. If you have a guardianship for another person, if you hold the guardianship, can you put that guardianship power in your power of attorney and give that guardianship right to someone else?
A guardianship is a court order.
Right.
So what you do and what I do is you put in the power of attorney that if I should need a guardian or conservator, I would like this person, it's my intent that this person be named. That is given some clout.
No. I'm sorry, I must have not been clear. I have a guardianship for a severely handicapped child, an adult child. And so that's fine as long as I'm able to manage. But if I'm incapacitated, can I give that guardianship
No, ma'am.
away in my...
No, ma'am, because that is a court-ordered guardianship. That is a court that says that you are qualified to do it, and you are given certain documentation that gives you that right under the guardianship. So you can't just give it to somebody else. You can't say, hey, Suzanne, I want you to do this when I'm not able to.
Right.
So, no, they have to actually qualify for that. There's generally bonding, surety, various other things that you have to do to qualify. That doesn't mean they won't. You can, say that I'm hoping this person will do it, but they have to qualify.
And if I should leave the state of Virginia, does that guardianship follow me?
Yes and no. I mean, you're still their guardian, but if you leave the state and they leave the state, then they're no longer Virginia residents. The court will potentially lose its jurisdiction. So you really need to go wherever you're going to go and have it requalified so that you don't. Again, the whole idea is not to have any issues
Right.
with any of these documents and not to have anybody question your authority. When you're talking about powers of attorney, medical directives, guardianships, conservatorships, you have authority to do certain acts, and you want to make sure that that authority follows you and that nobody is going to question it.
Okay. That's good advice. Thank you.
Suzanne, could you, and I'm just curious, how many of you know what a guardianship is? How many of you know what a conservator is? Could you just take a couple minutes to explain what those are? Because those are the alternative. If you don't have a power of attorney, that's what ends up happening.
Right, and we touched on that if you don't have these documents, you can wind up in a guardianship or conservatorship situation. But these documents help negate the need for them. Don't always get rid of it totally, but they do very often do the job. Okay, so a guardianship. If somebody is incapacitated, severely handicapped, Alzheimer's, whatever situation is involved. When that person can no longer take care of his or her own needs, they often need a guardian. The same way you're the legal guardian of your children before they're 18 years old, essentially it's the same thing. You're the person who has all the rights and all the responsibilities for that person's needs. Conservatorship specifically refers to finances, money, and property. So that is the person that handles the money, the property. Now that can be the same person, in which case they are the conservator and the guardian. It can actually be split between two people. And that is a court-ordered situation.
And it's a terrible thing to have to go through to get, and I say terrible. I had one recently, and I know Suzanne does this too. I had a lady who had Alzheimer's who wasn't taking her blood pressure medicine. And so she was at severe risk of clots, and it was down in Fairfax. And it took me 3 weeks. She was off of her meds for 3 weeks while we waited for a judge to enter an order allowing somebody to get her admitted to a psychiatric facility. And so I don't remember what the exact cost was, but it wasn't cheap, many thousands of dollars of attorney time to get it done. You actually have to have the attorney go into court. Everybody has to appear in court. You have to, oftentimes, if it's opposed, have a doctor do an analysis. So it's a very painful proceeding costing thousands of dollars, and compared to a power of attorney, which is relatively cheap and inexpensive and doesn't always solve it, but often can.
Right. And I had one, in fact, I'm still working on one where we had somebody who needed to be in a facility, and the son has been paying for it out of pocket for now, but he's running out of money, and they haven't been able to access the bank accounts up until recently. And it took a while because we actually had to get a guardian ad litem which is an attorney that's appointed by the court to represent the person that you're trying to get the guardianship on. So now they're paying for me and for her, and we had to go to court a couple of times. We finally got a temporary guardianship because now they're trying to get some work done with the VA, and they're having a hard time, so the guardian ad litem is going to bat on that, trying to get help for her ward, because that's essentially what you're dealing with at this point. So yes, if they had just had a power of attorney, we could have avoided all of this. They had a medical power of attorney, and they were able to take care of the medical, but the finances wasn't on the bank accounts, couldn't access the money, so couldn't pay for Dad's care and his Alzheimer's unit. Is paying it out of pocket.
If you name two people as in your power of attorney, and one of those people passes away, do you have to drop a new document, or can you have a survivorship type of clause in there?
There's multiple ways to do that, and if you name them successively, it means that you only have one person, so now you're down to one person, so you often want to do a new one that now names two again. If you name them jointly, you're in the same boat, although the other person usually just takes over for a while. But again, you're down to one person, so you often want to get it redone simply so you have that another successor again, and you're not, because what if something happens to that person? You're back into guardianship land. Any other questions? All right. Thank you very much again.
Thanks, Suzanne. And if you all think of any other questions, there'll be an opportunity at the end. I'll pull Suzanne back up, and we'll also have the other folks here who are able to answer any other questions you think about as we have the next couple speakers come up. Thanks to Suzanne. I can't stress strongly enough how important it is to have one of these documents and to be careful about how it's worded and who you choose. Just have to share a quick story before Wendy Dunn comes up. I had a client recently, and they were 4 siblings, a family of 6. And the youngest brother, when his mother was on her deathbed, literally on her deathbed, she was on morphine, out of it. The youngest brother had the power of attorney. And about a week before she died, she received an inheritance of $300,000 from her sister's estate. Her sister had passed before her. The youngest brother took the power of attorney, went to the bank, and took all the money. And then the folks came to see me, and we went to court, and we got a judge to order him to pay it back. Only one problem. Y'all think he still had the money? No. Long gone. We're still working. We've recovered a small percentage of it. But in many of these cases, once that person or somebody who's irresponsible takes the money, it's gone. So you do have to be very careful with how it's worded, what power you are giving, and then also who you give it to. So we're shifting now from the legal side of what powers of attorney do, how they work legally, to we wanted to give you a practical feel. We wanted to have some people who actually use them talk to you about them and how they come into their use on a daily basis or whenever they actually see them. And the reason is, again, the same with advanced medical directives. The point here is to get these service providers, whether it's the hospital for advanced medical directives or it's the doctor, or whether it's a bank or some sort of care facility for a power of attorney, to actually accept them. Because as we all know, and I mentioned this before, we're in a very litigious society, which is great for attorneys, right? Nobody laughs. But it makes hospitals and doctors and banks very, very cautious, and they're literally scared. They have insurance requirements and other things. So you want to make it very clear and very easy for them to do what you want them to do. So the next speaker is Wendy Dunn. She's a branch manager at United Bank, and she's going to talk to you a little bit about how powers of attorney she uses them and some of the things she looks for. So Wendy.
Good morning. Thank you for having me. I don't have a whole lot of information. It's very basic. A lot of what Suzanne and Josh was talking about is pretty much covered it. However, it's so important that you bring in your power of attorney or attorneys with you. I mean, not your power of attorneys, your attorney in fact, your POAs, who you have appointed as your power of attorney. Bring them to the bank with you. And the other thing is most banks will not just accept a power of attorney the day, say something happens and your son or daughter wants to come in and conduct a transaction. It's not going to happen that quickly. Bank is going to review the power of attorney. A lot of the things that Suzanne and Josh talked about, they are going to look, what have you said in that document? What can they do for you? Can they access your safe deposit box? Can they conduct transactions on your account? Can they open an account for you? So those are the things that we are going to look for. We are also going to require that you bring the original in, and then we will make a copy of the original. Keep in mind that each bank may have different policies, but as for us, what we require is that you bring the original document in. We will make a copy of it. We will put it on file. We will place a note on your file. So if you change your power of attorney, you need to let your bank know right away, because there's a note on your account that Susie Smith is your power of attorney. So if you change that in any way, and you want to make sure you let your bank know and make sure that they note your account, because you don't want, if there's an issue and Susie goes into the bank and you haven't notified the bank, and you end up in a situation where you have to call Suzanne or Josh because they've taken your money out.
Wendy, sorry to interrupt, but you were saying earlier to bring them in with you.
Mm-hmm.
So this is when you actually first get it. You actually take the person in with you to the bank to introduce them along with the document. Is that your recommendation?
That is my recommendation. You don't have to do that, and we understand that a lot of times your power of attorney or the person you've designated may be out of town, out of state, but it would be nice, and I will tell you, the ones that a lot of people that do that, it helps the bank know who that person is. There's a lot of things that factor in. We can know that person face to face. We know them when they walk in, and we're not having someone we've never seen before come in and say, I'm a power of attorney for John Smith, and I want to take out $10,000, some red flags go up at that point. So we are very cautious. You can imagine that there's a lot of fraud and identity theft. So your bank is going to look at your power of attorney, request the original, and review it very carefully before it's approved. Most likely the power of attorneys, when you walk in with them, they're not going to be approved by the person at that branch. It's going to be reviewed at from someone higher up.
Now, Wendy, if you've gone in before and they have your power of attorney on file and they've met your agent, and then that agent walks in, will that transaction occur quickly then?
Yes. That once the power of attorney has been approved, notice put on your account, we keep a copy of the power attorney in your file at the branch, and then if someone comes in and they want to transact, then it's seamless. You just check the ID, check the power of attorney, and it happens.
My question is, part of that can be avoided if the accounts are joint to begin with, if you have the other name on the checking account, on the savings account?
Absolutely. There are a lot of different things that you can do with your accounts. Some people are fine with putting someone on a joint account. However, you can change your power of attorney, but once you put someone joint on your account, you cannot change that. You will have to close that account and reopen another account. So we have a lot of clients that their son or daughter is on their account jointly with them, but once you place someone joint on an account, it cannot be changed.
Can another name be added?
Yes, ma'am.
Without closing the account?
Yes.
Okay.
Hi, thank you. Would I be able to put in a power of attorney document, say, I'm younger than my father, naturally. Would he be able to put in his documentation for the bank that says when something does happen or if something does happen, transfer the account into a certain name rather than sharing a name on an account or bringing that person into the bank?
That would be a question for Suzanne and Josh, because I will tell you that anytime there's one of the things that we're going to look at is it a basic power of attorney? Is it very clear? We want it to be very clear. So I can't say that that is something that we would accept.
I can say that legally that document would not work. That's essentially a will, is what you're talking about. Is on somebody's death, this happens to such and such. But what you can do, and what Wendy can talk about, are survivorship or payable on death accounts, which I believe you can easily set up, which I think would accomplish the same thing you're talking about.
Okay, great. Thank you.
Yes, you can set up PODs on your account. For example, someone just mentioned what would happen if you had two people listed as power of attorneys for you and one passed away. We had that situation. It was a mother who had her oldest daughter and her middle son as power of attorneys. Her middle son passed away, and so they changed the POA and added her youngest son and the oldest daughter. Then on some of her accounts, she has PODs. So they were asking questions about that and wanted to know what happens when, if the mother was to pass away. The POD comes in with a copy of payable on death. So a POD, if something would happen to the mother, the person listed as the POD would have to bring an ID and a copy of the death certificate and could receive the funds on the account.
You said the document had to be reviewed before any funds could be released. How long of a period of time is that?
The document has to be reviewed in the very beginning. So that's why we're saying when you set up your power of attorney.
But suppose you didn't. and somebody, comes in and you said it had to be sent somewhere to be reviewed, what period of time are you talking about?
The other day, it was a matter, they came in late afternoon. We had an answer for them the following morning.
And there's no legal precedent in Virginia where you have to bring that person in to meet you ahead of time? It's
No.
just something your organization likes to have done?
It's just a suggestion. It just makes it easier for the person handling the transaction. If your son or daughter comes in, then we get to know them. It's just a little added security feature there. Any other questions?
Is it not true that if you have a payable on death account, that keeps that part of the state from going to probate?
It depends on the account, but most of the time it does, yes.
I thought it was a dollar amount on what this gentleman just said. If it's over a certain dollar amount, there will be probate on that type?
You're confusing two issues. One's the payable on death account. The other is whether you can go through, what's that? It's the expedited estate. Yes, thank you.
Well, it's the death. I think they call it the death tax, too. That's supposed to be gone, but it's there.
That's yet another one.
Yeah, that's on that one. And
no, sir, you're confusing three different three different
I'm sorry.
issues. So, come back on the third. Come back next time, and we'll talk about wills and estates.
Yes, sir.
Yeah, I think my question is probably going to be answered next time too. But I'd never heard of a POD before, and I was just wondering where a POD comes between the POA and the will.
You like all the acronyms, Rhoda. Where it comes between them, what do you mean? So a power of attorney is effective, as Suzanne said, up to death. Will is effective after death. This is what happens. Payable on death accounts, how most of them work, and you have to read it carefully. Don't go out and get a payable on death account and say, Josh Hummer said this is supposed to do X. But how most of them work is when you die, as Wendy just said, your whoever is named as the survivor, or not the survivor, the designee, goes in and can get the funds. It's a way of passing funds most of the time outside the probate process, as this gentleman was referring to earlier. So it'd be the same as if you had an investment account and you had a beneficiary named on that. When you passed, that account is not going to go through your estate. It's not going to get divided up by the court. Whoever is that beneficiary is going to get those funds. You can do the same thing with a payable on death account or a POD. Does that answer your question?
Any other questions?
What is the difference between a POD and TOD, transferred on death?
In my understanding, they're the same thing. Transfer and payable. No, you don't have to have both, but they are similar. Again, it depends on how the account is actually set up. They're different types of accounts, but to me, they're almost identical.
Yeah, I'm hearing a lot of discussion about paper and ink on paper. Is there any national repository database that can house this information that governs $1 trillion of administration?
I'm not aware of any. Suzanne, are you aware of one? Yeah. Yeah. Hold on just a second.
My understanding is that you can for advanced directives, although that is a very new registry for Virginia. And if you're in West Virginia, they have one also. But for powers of attorney, no, it's still pen and ink. There is no electronic database that I know of.
I will say, sir, one way you can effectively do that is through taking a copy and putting it on file with your various financial institutions. It's not nationwide, but say you bank at United and you also do investments with them, or maybe you have insurance through them. You get them one copy and it covers the various different areas. So it's not nationwide and through various providers, but it does get it into the cloud with that particular bank.
We don't keep the originals for you. Lawyer on demand, we don't keep the originals for you. Sorry.
Any other questions? Thank you.
Fantastic questions. Thank you all. Thank you, Wendy. All right, the final speaker today, we also wanted to get you some experience, or someone who has experience in dealing with powers of attorney in a care facility. And so Danielle Palmer is actually on staff here at Westminster Canterbury, and I'll let her tell you a little bit. I got the name right, Danielle, didn't I? Okay. She gave me a look, which normally in my experience means you've butchered my name or forgotten it, which has happened already once today. But I'm going to let her tell you a little bit about her background and experience, and then also talk to you about how she's seen powers of attorney used with the care facility she used to be involved with. So Danielle, please.
Good morning, everybody. I was actually very honored to be asked to come and speak to you, so thank you for those that nominated me. I actually have had going on 9 years of experience as a social worker and 2 years as a nursing home administrator. So for those 9 years, I've had a lot of stories to go along with this subject, and I actually have 2 stories to give you the human piece of what power of attorneys can and cannot do for you. The first one is it comes from a nursing home, just plain out nursing home. A resident had came in for some rehab. He was a younger man, excellent health, just had a total knee replacement. So he was only there for, 2 weeks, 3 weeks max, just to get that therapy and to return home. Didn't have anything in place. Listed on his face sheet, which is just a general sheet of paper that goes over who your emergency contact is, a funeral home, where you live, social security number, and so on and so forth. He didn't have listed that he had a power of attorney, medical or financial. Unfortunately, he had a massive heart attack. Unfortunately, it went to the ethics board at the local hospital. There was no person in place to say what Dad's wishes was. And as most of you all know, with the ethics board, they're going to take the high road to keep that resident alive. It was very sad. We were there through that whole process with that resident. And, throughout the whole communication process, the family's like, Dad would never want to live like this. And unfortunately, he did end up passing away. But it was very sad. But he just felt that there was no need to have a power of attorney. There was no need to have anything in place. No advanced medical directive, nothing. And unfortunately, we can see what the problem lied. The next here that I have is about a guardian, and thank you, Suzanne, for talking about that. A resident in the nursing home had a power of attorney. In the unfortunate event, the people that she had listed as her power of attorney declined to do it any further. They had moved, still in the state of Virginia, but had moved, significant miles apart from where she was living, and they said, I'm not doing it anymore. At this stage in her life, she had advanced Alzheimer's and had to go through the guardian process. The unfortunate thing is she actually had to go to court. A person with advanced Alzheimer's, with her behaviors, with her, just the way that she was communicating, was not very pretty. So with that, it took 6 months to get her a guardian. 6 months is a long time when, at the end of your life, you're not sure where you're going to be at. She didn't have any friends or family to visit her, and she relied on the nursing home staff. But that is unfortunate that she had to go through that. So, mind you, another good reason to why have a power of attorney in place. I also wanted to let you all know that here at Shenandoah Valley, Westminster, Canterbury, they do have their own generic power of attorney forms. I see some of you all that obviously live here, and if you are interested in seeing those, I can provide a copy to you, and I have brought my business card for that. It's very generic. It's not as advanced as the two lawyers in the room would probably prefer, but that's all right. It's just very generic. It's only a page and a back page. There's only 2 pages long. When we were going over the 6 tips, which were actually 5 tips, I wanted to say about being careful who you choose. That was one of the tips. Make sure that your POAs are updated. I have had lots of experience with families falling out with each other, divorce, or one of them are deceased, like someone over here said. And lastly but not least, I did want to mention, and I took note of this while you were talking, sir, in the blue and white stripe. Here at Shenandoah Valley, Westminster, Canterbury, is the first time that I have ever dealt with POAs that are through a local bank or a credit union or a trust company or whatever it may be. And they are also invited to your care plan meeting, which is something that happens on a quarterly basis that gives an update to those people about your care and what is going on in your life here at this facility. Also, they are invited, as we invite anybody that is listed on the face sheet, what I spoke about first, to come to family council. Family council will also be giving information to your trust company or to your power of attorneys or your children, however you may look at siblings, or some people are just friends. And that way, all of the information is provided and that they won't be left out. But that's here at our facility that they get invited to so that they're not left out. Any questions?
Any questions? Okay. We got one over here. I'm sorry.
So do I understand that instead of going to either one of these attorneys for power of attorney, I can come to you since I live here?
I don't want to say that. I'm saying ours is generic. I can provide you a copy of it to look at. And then you're more than welcome to see these 2 fine lawyers. And they can go over, well, you're the lady that has the one from PBS or something, so you might be able to compare it.
So I bring Susie Ormans and look at yours and then decide what I'm going to do. And my own attorney's down in Charlottesville talking to me.
Yes. I mean, I don't want to say don't go to a lawyer, but I have had a lot of experience with Adult Protective Services. I'm sure you're all familiar what that is locally, that the Adult Protective Services actually provides a power of attorney, both medical and financial, that's very generic and has been very successful in the nursing facility arena. So again, it's really basically what you want in your power of attorney. If you want it more depth, then it's probably best to go to a lawyer.
Any other questions? Clear as mud.
Thank you.
Thank you. I guess I'll just stick with this one. All right. Thanks a lot to Danielle for talking to us about that. For those of you, she was talking a little bit about advanced medical directives, and we talked about those last time, but that's another great reminder that you do certainly need those as well, in addition to the power of attorney. On the last comment, obviously, our preference, Suzanne's and my preference, is for you to go see an attorney. There are other forms that work. We're not saying those don't work, but as you've hopefully gotten a little bit of a feel for today, this is a complicated process, and it shouldn't be, but unfortunately, trying to make sure that your power of attorney does what you want it to do is not easy and straightforward. It's not the one-page document that it used to be that says, I tell Bob, I nominate Bob, and Bob can do anything he wants to do. It's gotten more complicated. Before we close, though, if you've been sitting there thinking, I had another question I wanted to ask Suzanne or Wendy or Danielle. I want to open it up one more time before we close, and then we're going to have just a quick discussion about the file of life, and then we will be done. Any more questions? All right. Well, certainly feel free to. Oh, yes, ma'am.
It's not really an It's not really a question, but it's an observation that it isn't a one-time thing sometimes. And so, if you start with something that's generic, at least you've made a step, and then you'll find on your own that you need more, and so it's really a long educational process.
It unfortunately is, along with your entire estate plan. It's something that you can start small and move on to. The only caution I would offer is that sometimes starting small and broad can wind up getting you into trouble because either what you have doesn't work or it ends up giving somebody too much authority and they end up taking advantage of you. But yes, you're exactly right. It is a long process, and it's something that shouldn't end just because you have one or you got one in the past. And it doesn't mean that you're good from now until whenever. It's something that needs to be looked at again and again, and the same with your advanced medical directive, and as we'll talk about next week, your estate plan. It's something that unfortunately needs to be reviewed, not only because laws change, but because you change. You may look back and say 5-10 years ago, I can't believe I wanted this. I need to fix that. And as Suzanne mentioned, I can't tell you how many times we have a divorced spouse listed on a power of attorney or on a will. And of course they didn't want that. I mean, they spent $100,000 fighting him in court trying to get divorced from him. They don't want to leave them all their estate, but it's still there. It's in the will. And why? They just didn't think about it. So it's a good practice to have to review these constantly. One thing, Suzanne, one question that I had that I'd like you to address briefly before we close. How do you change this? How do you change a power of attorney legally and practically?
Well, practically, there are multiple avenues to do it. You have to revoke it, and revocation occurs in a few different ways. One is you can tear it up, shred it, burn it. You can deface it by writing all over it, and I know Josh probably tells his clients this too. Don't write anything on legal documents. Don't make handwritten changes on them. You are potentially really making a mess of your documents. The other thing is to do a new one that says, I specifically hereby revoke any prior documents I have done. But then you have and in all these cases, you then have to tell people that you gave the powers of attorney to, Wendy at the bank, Westminster Canterbury. You need to let them know that you have revoked and redone and renamed somebody else in your new power of attorney. Because I think Wendy brought this up, that if you have it on the file that you've named Bob Smith and you've changed it to John Doe, well, they don't know that. So those are the best ways to do it. You can tell somebody you revoke it. I can say, Josh, I revoked my power of attorney naming you as agent, but then you better have some witnesses around, because he doesn't have to be honest about it. He could still go to Wendy and say, I need to take $10,000 out.
Right.
So those are the ways to do that. You have to revoke it. You can do that by physical act, or you can tell somebody, or you just redo another document saying that you've revoked it.
And you recommend people do all of those, correct? You recommend you do
you
it.
Do the new one, and then you shred or tear up and dispose of the old one, and of course let everybody know that you have done a new document.
Okay. All right.
Names on it.
Sure. I think we can pull that one up for you. We'll make sure that's up before we leave, so you see everybody's names and you can get the correct spellings. Yes, sir.
Is the 5 wishes document off topic?
Does the 5 wishes have a financial power of attorney in it? I don't think it does. It's not off topic, but I mean, feel free to ask about it, but it doesn't have a financial piece to it.
I presume that'll be covered later.
It was covered somewhat in our advanced medical directives presentation. Yes, sir. Any more questions? Excuse me. Thank you.
Is a POA that is drawn up by an individual using another one as a reference point and have it notarized and witnessed, is that legal as going to an attorney and having one drawn up?
Suzanne, you want to handle this one? Do we have another mic over there? Here we go. Hold on.
I feel like Monty Hall and Let's Make a Deal. And I can say that here because everybody knows who Monty Hall is. In every state is different as to what the requirements are for legalization of a document. So having a notarization for some documents is not what makes the document legal. For example, Josh will talk next month about the fact that a will, what makes a will legal is not the notarization, it's the witness's signatures. However, if you have a power of attorney in Virginia notarized, that is legal in Virginia. And it doesn't have to be at an attorney's office, but it does have to be done in the proper format, meaning that you can't sign it and then have a friend witness your signature later on. It has to be done concurrently. They have to watch you do it.
So under Virginia law, if I'm understanding Suzanne correctly, there's certain formalities that you have to follow in order for your power of attorney to be valid. And if you follow those, it doesn't matter whether you do them in an attorney's office or on the beach or wherever. It doesn't matter what kind of ink you use or whether you print it out or whether you handwrite it. But as long as you follow those formalities, it's valid. If you don't, it's not valid.
Thank you.
All right. Any final questions? Seeing none, what we'd like to. Did I go too fast? Sorry. I felt like the going, gone. All right. Oh, I'm sorry. One more.
Are both of you from the same law firm?
We are not. Suzanne works for the Suzanne Herskovitz PLC. Is that right? I missed the middle initial. I'm with Lawson and Silik. I'm with a firm, a different firm in town. We both work together in providing information to seniors in the area.
So when we close up, I can get a business card from each of you?
Technically, we're competitors, but we're actually friends as well. So there's not, we refer to each other and we work together on various things.
Okay, so I'll get your business cards before you have
Sure.
them with you.
As part of TRIAD, one thing we've done is and this isn't original to us. I guess Sue Vantine actually came up with this, and we talked about it a little bit last time. But we've come up with what we're calling the file for life, and we have a number of them up here for you all to pick up. And I'm going to turn things over to Rhoda now to review those. I think we went over them. I went over them a little bit last time. I didn't do a particularly good job, but Rhoda is going to give you a more in-depth look and do a better job of explaining what they are and why we think you all should have one. Rhoda?
Thank you, Josh. This is something that I firmly believe in. I think every household should have this on your refrigerator. We do have some up here. It comes with 2 magnets on the back. You stick it on your refrigerator. When the rescue squad comes in, they grab this and go to the hospital. This has in it every bit of information that you will need to tell the hospital when you get there. I brought the one from our refrigerator. The first thing is just basic information about yourself. We got this. I live over at the Village at Orchard Ridge, which is a retirement community exactly like Westminster Canterbury. We have individuals, we have people in health care, but everybody should have this on the refrigerator. This is my admission for Orchard Ridge, has all the information on it that they need. The next thing I have is the list of medicines. George and I make a new copy of this every time we go to the doctor. We hand it to them. It has all of our medicines on it, and it also lists all of the surgeries we've ever had. That can also be a very important thing when you go to the hospital. The next document we have in it is the Advanced Medical Directive. Now, I will admit I do not have a power of attorney in here. I have a list of our doctors, all the doctors that we see. Here's another important one. Social Security, insurance cards, copies of those. Consent for treatment, we have signed up with a home care so that if we need to have help in the apartment where we live, we can have assistance with that. We have the copy of the agreement with that so that if the rescue squad comes in, they know exactly who to call. And you've all heard of HIPAA. HIPAA keeps anybody from knowing anything about you. You can, we have a little release we can sign saying that the administration, the nurses, everybody at Orchard Ridge can share the information, because sometimes some of our neighbors go into hospital or ill and we have no way of knowing it unless they have permission to give out that information. So sometimes you just need to let them know that you are willing to share your information with other people. So those are very important papers to have in the file of life. And like I say, they just take it right off the refrigerator, take it with them. If you have a DNR, a do not resuscitate, that's very important to have in there. The rescue squad would need to know that. Or anybody who comes in, I say rescue squad because that's a, if something happens to you at home, that's usually who shows up, who you call with 911. All that information, the do not resuscitate, your directive, all the medicines that you take. There used to be just a little file, remember the little test tube type thing that you put in the refrigerator with all the list of your medicines on it. But now this is so much more expanded and so easy to use. So anybody have any questions about? And we do have them up here. Okay. One other little thing. We ask you to write down anything that you would like to see for future presentations. Would you also write down where you heard about this program? Because we are always looking for methods to get the word out that we are having educational workshops or seminars, and we want to know the best way to get that information out. So if you would just write down whether you heard it through the newspaper, from a friend, in a newsletter, however you heard about it. We'd appreciate it. Okay, anything else, Stephanie? Anything? There's still some...
Yes.
Still some refreshments over here.
Yes. Thank you all for coming this morning. I hope this session was very helpful and informative for you. As she mentioned, we still have several refreshments and coffee. So if you want to refresh your plate and catch up with some of our speakers, feel free to hang around for a bit. Thank you again. Yeah.
Hey, before you leave, young lady, make sure you leave a card for me. I thought you were running toward the door.
Thank you so much. Have a good morning.